All right, so today what we are looking at talking about, so welcome everybody. Today what we're looking at talking about is in-house assets and our inclusions, our exceptions and our restrictions as they apply. And so what I've done effectively for the remainder of the calendar year with regards to these webinars is I'm writing a bit of a, I guess I'll call this a bit of a series where talking about in-house assets. Then next month we'll talk about acquisition of assets from related parties. And then we'll round it out by talking about SMSF investments in unit trusts. And I find these subjects are intrinsically linked, and they're linked primarily because of the in-house asset rules. So when we talk about acquisition of assets from related parties and other things, I think it's important to have a broader and greater understanding of the in-house asset rules to be able to discuss it, and then to discuss it from a client point of view. So with today's webinar, I do want to focus on the core issues around in-house assets. For me, it's one of those areas where, I mean, I've been dealing in this space, as we know, for a long time now, and it's still it's fascinating because the rules really haven't changed or at all in regards to in-house assets since self-managed super funds became a thing in 1999, and it was actually the introduction of self-managed superannuation funds, as I'll touch on throughout the presentation, that really led to the introduction of the in-house asset rules as we know them now. So the changes came about in 1999, basically on the assumption that there were all these related parties going to be involved in superannuation. And so it was a bit of a protection mechanism having these in-house asset rules. So it moved from what was employer sponsors in the earlier days, in the pre-99 sort of period, to more broadly relatives and other sort of controlled entities moving beyond that 99 period. So the rules have remained relatively stable in that entire period, but I think where it's an issue is that the understanding really hasn't changed. Like, it's an area that as we talk through it, we'll notice that, and these are the sorts of things we're going to talk about today, but as we notice when we look at the tax office statistics in regards to in-house assets, that it's still the second biggest breach by number of breaches performed in the SMSF space, behind that member loans element. And then there is clearly a link between loans and in-house assets, and I'll touch on that. But more importantly, basically a quarter of all breaches from a value percentage point of view are in-house asset breaches. And ultimately, my reckoning on that is because when you breach the in-house asset rules, what you're doing is you're breaching the 5% element, and is therefore becomes based on the value of those assets. And I think that largely a number of the breaches are linked to our Division 13.3A trust, so our 13.22C unit trusts and companies, and given that they make up a reasonable value of most funds that they sit within, then if there's a breach, it is going to be quite a high percentage. So, it's one of those areas where when people get it wrong, from a valuation point of view, it certainly looks a lot worse, because you're effectively dealing with quite often quite large assets. So, from an investment restriction point of view, the in-house asset rules, as I said, still a bit of a minefield for some people to work their way through. But realistically, when you actually work through the concepts, and I'll talk about and touch on at the end of the session today, sort of the questions that I always try to pose when talking to people about making investments inside their fund. If you follow a few simple rules, then ultimately you're going to find yourself in less trouble. In saying that, of course, the main thing is that for a lot of people, where the in-house asset rules become a bit of an issue is that what they're trying to do is they're trying to get their self-managed superannuation fund to invest in some form of related entity for varying ranges of purposes. And because the rules around that can become quite strict, people get in trouble either by not knowing who's a related party, or by not knowing the rules around those related party investments to make sure that they get things right. So let's work through some of the key things. And of course, the first thing that we need to understand is what an in-house asset is, right? And so it's easy to talk about these sorts of things from a transactional point of view, once we understand what they are, what in-house assets are, but importantly from that, expanding then into what also is not considered to be an in-house asset. And so it's really a lot for us to work through. But the definition itself is pretty straightforward. A loan to or an investment in a related party of the fund, an investment in a related trust of the fund, or an asset of the fund subject to a lease or lease arrangement between the trustee of the fund and a related party of the fund. So that's it. Right? It gives us a fairly simplistic definition of what an in-house asset is, right? And we then have to extrapolate from that to work out, what certain terms within that definition mean. And the tax office have provided that to us, and they did that back in 2009. So again, from a ruling point of view, the information's been available to us for a significant period of time. What's interesting is when I go back and review some of those early ATO rulings from sort of like 2009, 2010 to even 2008 type period, the rulings are quite good in what they do, but I think they still lack a little bit of depth in certain areas. And I think we see that now with ruling changes to, say, the contribution rulings and pension rulings, where the tax office have possibly advanced even in their knowledge in some of these areas over the last sort of 15, 20 years. And so they're taking the opportunity to expand upon some of the key issues within these rulings. Whether they do that with some of the in-house asset and financial assistance and all that sort of stuff, only time will tell. But even rulings like the business real property ruling, which is pretty important when we start to talk about related party investments, what is business real property now is, to a degree, quite different in some circumstances to what was business real property back 20 years ago. So there's key elements that we need to be mindful of. So we need to have an understanding of some of the terms within this definition, and how that applies not only to the in-house asset rules, but to other investment restrictions as well. And so, as I said, the tax office have provided us historically with some good guidance in regards to some of this area. And the first thing that we reference there is a loan. So when we talk about a loan in the SMSF sense and from an investment piece, it's a broader definition than the idea of the reverse of a borrowing, where you borrow money with an intention to repay. The same with a loan is you lend money with an intention that money is going to be paid. That's our standard definition of a loan, sort of summarized pretty simplistically there. But from an SMSF investment point of view, we have far broader, and we've got a ruling that deals specifically on financial assistance, right? But we also then have our 2009/4, and we also have 2009/3, which talks about unpaid trust distributions. And so the timing of all this was very deliberate from the regulatory point of view, because we had effectively pre-1999 investments that were only in-house assets in very strict terms of standard employer sponsors. And so a lot of related party investments were then given an exclusion to the in-house asset rules, and I'll cover off on that shortly. But then there was also a transitional period, a transitional 10-year period that provided for additional investments within those investment vehicles that would also be excluded from the in-house asset definition. And what was key was that transitional period ended at 30 June 2009. And so we saw a lot of material coming out in 2008, 2009 about how we dealt with certain specific areas. And so it's important to focus a little bit on that 2009/3 ruling about unpaid trust distributions, because what we see now and what we've historically seen from an SMSF point of view is a lot of funds do invest in unit trusts, and they invest in related unit trusts. Now, the key consideration of investing in related unit trusts is that, as we know from an operational point of view, unit trusts must pay out their distributions, right? So the unit trust must provide their distributions to the unit holders, and you've effectively got let's call it as soon as practicable guideline sitting around that trust distribution. Now, what the tax office have said in 2009/3 rulings and in other circumstances as well, particularly around, as I said, that 2009 period, is the timing of that distribution is going to fit in within the concept of financial accommodation, right? So as soon as the distribution has been determined, so the financials for the unit trust have been finalised, then really at that point in time, the trust should be making its distribution to the superannuation fund. Now, of course, what we know and what we appreciate from a managed fund point of view is that we work on a cash basis in SMSFs from an accounting point of view, except with our managed funds, so except with our trust distributions where we work on an accrued basis. So we are accruing those trust distributions as at 30 June with an expectation that they're going to be paid. Now, from a timing point of view, it's also not uncommon to have trust distributions paid late in the financial year because the previous financial year is only being finalised late. So again, you know, the common scenario has often been that the unit trust is one of the last sets of accounts that is being prepared from an accounting point of view. So the final trust distribution is not known until late in the year, and if the super fund is not lodging its returns until, let's say, May, and is only getting its returns done for the unit trust at the same time, right, then we might not be receiving those trust distributions until May, June, even July, following the end of the previous financial year. And so, you know, what we're looking for there is that consistent with the practices of the unit trust? Is it consistent that the trust is prepared at a certain time, the distributions are paid relatively quickly after that point in time? If that's the case, then we haven't got any financial accommodation. We've just got a standard commercial transaction. But if the unit trust financials are prepared early in the financial year and the trust distribution is known, but it sits there still as an unpaid present entitlement to the superannuation fund, and the time frame sort of drags on a little bit, then we've got to consider the financial accommodation from the super fund point of view. And when we're talking about in-house assets, the concept of a loan could be that financial accommodation. Now, it's not automatic that it's a financial that it's going to be considered a loan, but in certain circumstances, it may be that the super fund is providing financial accommodation to the unit trust, and we need to treat that as a loan. So we need to have this broader understanding of the terms within in-house asset, particularly when we're looking at investments such as unit trusts, and particularly when we've got unpaid trust distributions. And as we work through the presentation today and I start to talk about some of the exclusions, that becomes even more critical to have an understanding. But yeah, so there's our first one, the broader definition of a loan. As I link some of this back to investment restrictions later in the webinar, one thing that is key is that Section 65 of the SIS Act prohibits the financial accommodation, so it prohibits us from lending money to members or relatives. So we've got Section 65 saying there's a prohibition on loans, and then we've got Section 71, which says an in-house asset is a loan to a related party. And as we're about to jump into, a related party includes members and relatives. So we've got this crossing of wires as such between various investment restrictions inside the SIS Act, and we have to understand what takes precedence. Now, clearly, if I go back to that table of breaches, we see still that the number one breach is loans to members and relatives. So just because there is a extended definition of loan inside the in-house asset rules, which incorporates loans to a related party, we still have to deal with all of our other prohibitions first. So we cannot lend money to a member or relative and say, well, that's an in-house asset versus a breach of 65. It will always be a breach of 65. Similarly, if we lend money to a related entity, related company or trust, who then on-lends that money to a member or relative, then we're effectively just accommodating that loan to the member or relative. And so a loan that would otherwise look like an in-house asset could be deemed to be a breach of Section 65. So we have to have an appreciation for that, because I have no doubt that many of you online get the same questions that I get asked quite regularly is, can we lend money to X or Y for the following purpose? And ultimately, we have to make an assessment on what that purpose is, whether that purpose is legitimate, and whether it then meets the requirements of Section 71. So it can be a fairly key issue with regards to this whole definition of in-house assets. Then we look at other definitions, other words within it, like an investment in, so to make a contract for the purpose of gaining interest, income, profit, or gain. So generally anything that the super fund is doing with its money from an investment point of view is for that interest of generating income, profit, or gain. A lease will occur when another entity is given exclusive possession of the asset in exchange for rent. And then a lease arrangement is the same as a lease, but it's not formal. And a lease arrangement, this was again fairly prominent in the pre-collectible and personal use asset days, where we used to talk about self-managed super funds that would own artwork or other kind of antiques and things, and they would effectively display them at their home, right, for want of a better purpose. And then the question would be, well, one, you shouldn't be doing that because you're getting a current day benefit. So that's obviously been taken care of with the collectible and personal use asset rules. But secondly, you should be generating revenue from that because it is a lease arrangement. So you are effectively displaying an asset that doesn't belong to you personally, it belongs to the super fund. And so there should be some form of consideration for that. So a lease arrangement is that more informal version of the lease. Now, of course, we still have lease arrangements from an investment point of view. And as I said, I'll talk about some various investment restrictions and other things as we go through, but also some of the exclusions there. But with the introduction of collectible and personal use asset rules that came in, or they were announced obviously back in 2011, then had our transition period to 2016, and we've now got those assets as being assets that cannot be stored in the residence of the member or their relatives as such. So there's some key considerations about our collectible and personal use assets, and they effectively are not in-house assets as such because they're under their separate own inclusion. So a key to a lot of this comes down to this definition of what is a related party. Now, for many of you who have been along this journey with me presenting for a long period of time, intending, you know that I've got a fairly common set of slides here that deals with related parties, and I'm going to run through them again, and I'll probably touch on them again over the next couple of months as well, because it's a critical element that we need to understand from this whole related party investment piece is who we are actually dealing with. And so when we talk about related parties, we're talking about the members of the fund, and that's hugely important when we're also then talking to people about setting up superannuation funds. And I started in this industry when it was in its infancy from an SMSF point of view, obviously not from an excluded fund before that, but in its infancy from an SMSF point of view. And the original definition of a self-managed superannuation fund, if you ever want to go back and read through the legislative thinkings of Parliament at the time, not suggesting you should do that, but if you want to, the original definition of a self-managed super fund when it was looking to be introduced back in 98, 99 was family only, right? Now, that obviously didn't go through in that sense, and it was more broader, and now you've got your exclusions to do with employers and other things like that, and there is a link back to being related, but it doesn't prohibit business associates, it doesn't prohibit acquaintances, it doesn't prohibit that non-related element joining in a self-managed super fund together. But then what the definition of related party does is it links you anyhow. So even if you're not related, then you are related. And so your activities outside of super then become far more relevant, because if you're in the same fund, you're connected by membership, and therefore your external investments potentially come into the scope of related party investments. You broaden the network of who is a related party to the individuals of the fund, therefore putting in place sort of stricter guidelines as to who the fund can or cannot deal with, or more to the point, who the fund can deal with on a restricted basis. Because, you know, the key thing about the in-house asset rules, and something that I'm always pointing out, is that what the rules aren't saying is that you can't do something. They're basically saying you can do it, but it's on a fairly limiting basis. So other than the loans to members piece, you can invest in related companies. You can invest in certain related trusts and that, but you can only do up to 5%. So it's a protection mechanism, right? Because we all think that our investment or whatever is going to be the next best thing, but the reality is, in most instances, it's not the next best thing, and quite regularly those investments fail. And so the in-house asset rules are, to a large extent, protection mechanisms to protect members from trustees making imprudent decisions with regards to the overall retirement benefits. And a classic example of that in a non-SMSF space is ANZET, right? And so for those that haven't been around long enough to know what ANZET was, it was obviously one of our major carriers, ANZET and Qantas. One of the things that happened was ANZET had their own super fund. So a lot of the airlines and that had their own sort of funds, employer sponsor funds for their employees. They had their own fund, they had their own employee fund, and they invested heavily in themselves, right? And so what happened was a lot of these pilots and other staff members and that they lost their jobs when ANZET crashed, but they also lost their super. And that's just one example of the significance of the in-house asset rules, is that overall protection mechanism that we're trying to build our retirement benefits, right, not get tax breaks and other sorts of things along the way. And that's one of the key things, and it's a sole purpose test and things that we have to remember. I've just jumped, into other elements there when discussing fund members, but it's all linked back to the broader picture of the in-house asset rules. We've also then got our standard employer sponsor of the fund. Again, very rare in an SMSF that we have a standard employer sponsor. That's an employer where there is a link between the employment and the contributions being made. So there's an agreement between the employer and the trustee, as opposed to super choice, which most of us operate under, which is a choice between the employee telling the employer where they want to contribute. So standard employer sponsors are not really a thing, albeit that they can still exist, but it's very rare that you're going to see them. And then you got Part 8 associates of the member or the standard employer sponsor of the fund. So we need to understand and broaden that out a little bit more. So we've got our members from a definition point of view. We've then got our Part 8 associates, and Part 8 associates expands membership to talk about the relatives, right? And we then need to know who our relatives are, any partnerships that the member is in, and any partners in that partnership, and then the spouse and children of the partners in that partnership, and then any entities that this broad group of Part 8 associates control. So a company that is controlled by Part 8 associates, or a trust that is controlled by Part 8 associates. So again, fairly significant into the depth as to what a related party is, for two reasons, really. There's two reasons that this is all critical. One is acquiring asset rules. So there's a prohibition on acquiring assets from related parties. So we need to know the depth of our Part 8 associates for who we are acquiring assets from. That's what we're going to talk about next month. And then the in-house asset rules. So we've got an at-point position, which is the acquisition piece. Can we do it? Right? And then we've got an ongoing review. Once we've done something, what is it measured against? Is it measured against the in-house asset rules? Is it measured against the is it measured against the exceptions to the in-house asset rules? Or is all of that totally irrelevant and it's just an investment in an unrelated party? In which case the investment is generally considered not problematic from a fund point of view. So we need to have an understanding of these various parties in that as well. Things like relatives, important to work our way through the definition of relative, and that definition under 10.1, so effectively under the related party rules, and then the broader expansion under Part 8 is slightly different to the definition of relative under 17A. And 17A, which is our definition of a self-managed super fund, incorporates relatives because there is an exclusion to membership of you can't be in the same fund as your employer unless you are related, right? And so therefore you need to know what it means to be related. And for whatever reason, they brought in two different definitions. So the definition of a relative under 17A includes the former spouse and the former spouse of anybody else, but it also includes cousins, whereas the definition of relative under our Part 8 associates excludes the former spouse, and it excludes cousins. But this led to a really interesting question that I had one day along the journey, where I had a client ring up and say, my self-managed superannuation fund owns residential property, right, and I want to lease it to my former spouse. Right? Now, the question posed to me at the time was, is that possible for the self-managed super fund to lease to a former spouse because the former spouse is not a relative? Right? And so when you look at it at face value, you go, okay, well, if we break it down, if we're talking about this is an asset that is not subject to a lease to a related party, then you could argue that a lease to a former spouse would be acceptable. But I sort of tried to say that a little bit further and say, well, have you got kids, right? Because if you've got kids, are those kids staying with the former spouse, right? Because, based on their age, there's a very good chance that those kids are also benefiting from it. And so indirectly, right, you are effectively providing potentially financial assistance, but in other respects, are you leasing that to the spouse, or are you actually leasing it for somewhere for your own kids to live? And I see that as hugely problematic. I mean, residential property is a whole thing in itself, but legislatively, I see it as problematic. So my answer at that point in time was, you probably should go off and seek legal opinion. But my direct position would be, no, you could not lease an asset to your former spouse. But it does create a bit of nuance within the legislation that there are people, right, that you've either been related to in the past, right, or people like cousins who you are related to, that there are sort of opportunities available in that space. So understanding all of these things are quite critical. And then when we talk about our controlled entities, so we've got our companies and our trusts, we operate under, firstly, a fairly simplistic approach, which is, what is a controlled company? And the first one is majority voting interest, right? So if the entity or entities are in a position to cast or control the casting of more than 50% of the maximum number of votes, it might be cast at a general meeting of the company. Right, so who are your shareholders? So when we're looking at a company, who are your shareholders? If those shareholders, right, have more than 50% of the shares to be able to cast votes, then it's a related company. So when we're talking about who those shareholders are, those entities, we have to revisit this image. We have to revisit this image of who the Part 8 associates are. So it's not just the members of the self-managed super funds, it's all the other related parties to the members of the super fund that will determine whether or not you have a majority voting interest. But also, of course, what's always been largely problematic, but also potentially largely ignored, is this 50-50 concept, right? And that is that if you only have 50%, then you don't have a majority voting interest. Now, as has always been pointed out to me, but if you do have 50%, no one else has a majority voting interest as well. And so no one else can control that decision. And so things like the casting votes and that become quite critical in those sets of circumstances. And the key with things like majority voting interest and with 50% is that there's this second arm of control, and that is sufficient influence. Right? And whilst it's a bit of a mouthful, it talks about if the company or a majority of its directors is accustomed or under an obligation, formal or informal, or might reasonably be expected to act in accordance with the directions, instructions, or wishes of the entity or entities, whether those directions, instructions, or wishes are or might be reasonably expected to be communicated directly or through interposed companies, partnerships, or trusts. It's quite a mouthful. What they're basically saying is, if you exert control through power, like positional power or experience power or other elements, then that is a controlled entity. So you don't need to have that 50% shareholding to have a related company. And then when we look at the definition of a related trust, we break that down to talk about a fixed entitlement to more than 50% of the capital or income. So similar to the shareholding voting piece there. Sufficient influence. So again, do you control the decisions of the trust? Or the ability to remove or appoint the trustee or a majority of the trustees. So one of the scenarios that will often come up when discussing related party investments and with discussing whether or not a transaction is going to be a related party investment will often be things such as joint ventures. Now, I don't want to go down a rabbit hole of joint ventures today, because that might be a webinar that we'll look at next year, is property investments and other things and paths to go. But with a joint venture, obviously, or not obviously, but often you'll get two distinct parties. You'll get somebody financing it, and then somebody with the experience in the field of the venture as such. And so what you might find is that self-managed super fund might be looking at investing in a joint venture with unrelated parties to do property development, right? But that self-managed super fund member brings all of the building experience, all of the knowledge in real estate or everything else, and so they actually have sufficient influence over that entity. So even if they don't have the majority shareholding or unit holdings, they actually might control it other ways. And then we've got an in-house asset that we need to be mindful of. And then we've got other sorts of things, because once we start talking about joint ventures, we're definitely most likely looking over that 5% limit issue there. Depending on the structure that we're investing in, we can have other sorts of considerations to think about. So there's a lot that we have to understand when dealing in this space. And I think it's why it's still that second number from a breach point of view. And it's significant from a value point of view, because people undertake large transactions thinking that they're going to be okay, but then they create a problem and the breach is actually significant in value. So it's clear that we need to have an appreciation for all of that. What we then do is we then move from what is an in-house asset. So we have this concept, right, a loan to a related party, an investment in a related party, right, or an asset subject to a lease to a related party. So we keep that quite simple. We then have to work through what, if anything, is excluded from that. Now, there's a couple of things that are in the exclusion list, which I've always kind of contemplated, but not too deeply. Why are they in the list, right? So why are deposits with banks? Why are life policies and pooled super trusts and that? Why are they in there? And I haven't really thought too much further than the concept of why, other than to say, well, I'll just continue to raise it there. Maybe one day I'll personally be enlightened. But to me, a lot of these issues are not necessarily significant from the broader in-house asset rule, but they can be significant, particularly with things like life policies, when we're looking at acquiring assets and what we can and can't acquire. And of course, life policies is one of those assets that we can't acquire from ourselves. Theoretically, we can acquire it if it's owned by another entity, but not by ourselves. And so there's some key issues there, and we'll talk about those next month. But then we've got, within this in-house asset exception, we've got things such as widely held unit trusts. So again, we have to understand what a widely held unit trust is. Come back to that in a moment. Property owned as tenants in common with a related party, right? So we're saying here, a self-managed super fund and a related party can own property, right? It's an exception to the in-house asset rules, unless we then lease it to a related party. So if we lease a property that is owned tenants in common, if we lease it to a related party, it's going to be an in-house asset. But then we have the further exception to say, unless it's business real property. So what we're really saying is, if we've got residential property, it can't be leased to a related party, or more to the point, if it is leased to a related party, it's going to be an in-house asset. And of course, it's likely in 99.99% of cases, that means it's going to breach the 5% investment restriction on in-house assets. The exception to that being the $200 million fund. They could potentially own a residential property that they lease to a related party, because it might come in under that 5%. But for the majority of others, it's going to be a breach. But then we've got our exception to business real property. And this is an interesting exception when you sort of go through the rules, because the other thing that happened in that 99-2000 timeframe, and a lot of this was sort of kickstarted in 98, was self-managed super funds could only invest, excluded funds, so the precursor to self-managed funds, could only invest up to 40% of their assets in business real property. So what we saw as part of this transition from excluded funds to self-managed funds was a recognition of those parties that weren't using superannuation as much as others, and they were referencing small business owners, right? And so again, what they looked at was said, okay, well, what's an incentive for small business owners Well, if we remove the 40% restriction on business real property, they might not have the cash to contribute to super, but they've got the investment, they've got the property that they're running their business from. And so what they did was they opened up that opportunity to say that you can invest up to 100% of the value of the fund into business real property. So it took away that 40% restriction. At the same time, they changed all these investment rules around related party investments. And they said, well, hang on. And so they introduced the concept of related party trust. And as we've just gone through, a related trust is an in-house asset. So then they had to build a whole heap of other exceptions around to incorporate business real property. So not only have we got the in-house asset exception here, we've also got our regulation 1322B and 1322C trusts and companies that provide for an exception to the in-house asset rule if you hold an investment in a related company or trust and the only asset of that company or trust is business real property. So it basically provided this overall benefit for business real property to be transferred into superannuation fund. So the expansion of that is that we then got other assets as determined by the regulator, other assets as determined by regulations, and that's where 1322C comes in, that became exceptions to the rules. So when we're working through the rules, not only is it important to understand what is an in-house asset, but more importantly, what isn't an in-house asset to ensure that we don't run into any problems and understand when we can invest 100% versus 5% of the assets of the fund. So that widely held trust concept, again, it's one of those weird, quirky little definitions where you can't get too small a group of people, a group of related people, and tie them in with unrelated people and say, oh, I've got a widely held trust, because there's certain definitions to meet, and that is that it's not a trust where fewer than 20 entities between them have a fixed entitlement to 75% or more of the income and capital, which basically means you've got to try and take a look at the top 19 unit holders, and if they've got entitlement to 75% or more of the capital, then it's not going to be widely held. So the most common example of a widely held trust is going to be our managed funds in most circumstances there. And remembering again that all of our related parties effectively act as one of those entities when we're talking about the fewer than 20. So all our related parties together become one there. But some of the other exclusions that apply is obviously the LRBA. So this was an interesting piece of legislation that came about sort of beyond the introduction of LRBAs, where we have a clear investment in a related trust. So our holding trust, even though it's a trust effectively in title only, is that the exclusion was built into the legislation that if you've got an asset subject to Section 67A and 67B, then the trust is not a related trust, so it's not restricted to that 5%, unless the investment of that trust, so unless what you bought under the LRBA arrangement is an in-house asset, then otherwise it's not going to be an in-house asset. However, the way that legislation was worded, it sort of put a restriction in place of this concept that said, okay, well, when the asset is subject to an LRBA, then it would be excluded from the in-house asset. What about in the moments before, like so when you put your deposit down or whatever, and so you've got the bare trust in place, but you haven't actually got the borrowing in place? And what about that point where you pay out the loan, and so you've still got the asset sitting in the bare trust? Would those 2 points subsequently be in-house assets? And so we saw the legislative instrument introduced at the same time or afterwards that restricted these assets to say, if the asset inside the trust retains the characteristics of an LRBA other than the borrowing piece, then it will always be an exclusion. So what that ultimately means is there is no requirement to transfer an asset from a holding trust on the payment of the LRBA unless you choose to make improvements and make changes which will change the nature of that asset. So it's not a requirement to pay out or to transfer the asset upon the completion of the loan. It's an option, and that's what 67A provides for, the ability to do that transfer. But you can retain it there as long as you continue to meet the requirements of 67A, which is primarily around the nature of the asset and not changing it, not having replacement assets and those sorts of things. So there's some key things to be mindful of there. If we look at some examples, then if we touch on things like the the tenants in common. So if Pat wants to buy an investment property from a third party using money from the SMSF and personally, so can this be done? Yes, it can. We can buy that property. Can Pat's fund acquire Pat's part of the house? No, we can't. Under Section 66, we'll talk about, as I said, next month, we can't do that. Can Pat or a related party rent the house? It'd be an in-house asset. So you see the distinction. I'm not saying no, you can't do it, but it would be an in-house asset, which would suggest it's highly unlikely that you could do it based on valuation. What if it was business real property? Then it would be okay. Could the fund acquire the property if it was business real property? Yes, right. So you've got this capacity to do that in those sets of circumstances. And the business real property test is really, it is an at acquisition test, but it's also on an ongoing basis as well. So you've got to be able to make an acquisition. It's not whether something will be business real property, it's whether something is business real property from an acquisition point. And then moving forward from a leasing point of view, so are you leasing business real property, has this continuation piece that you need to be clear on to ensure that that it continually satisfies the definition of business real property. The ungeared trust piece, so the 1322C, and as I said, this came about because of the changes to business real property, as I mentioned before. These changes came about to said, well, if you have an investment in a unit trust, yes, the law has changed to say it will be an in-house asset, unless the regulations stipulate otherwise, right? And so therefore we got the introduction of Division 13A, right? And in that division, it introduced 1322C. Now we've also got 1322B, but they are pre-2000, pre-28 June 2000 investments. 1322C is clearly what we're looking at from any investments that are made now. And if we meet the conditions of 1322C, then the investment will be an exclusion to the in-house asset rules, which opens up lots of opportunities. And so we'll talk about some of those next month when we talk about acquisition piece, but it also just ultimately gives us unitization of large lumpy assets, right? So if we can meet these conditions, it can be quite beneficial until we do the wrong thing. And if we do what is considered a 1322D event, then that is going to be problematic for the fund. So these 1322C vehicles are hugely beneficial in many circumstances for superannuation funds. But if we get them wrong, so if we do the wrong thing with the trust, then it's going to be a breach of the in-house asset rules, and you're going to have to unwind the investment in the trust, and that obviously is going to be a problem for a lot of funds. So what we need to understand is that the conditions that are placed upon it, the conditions placed upon the exception to the in-house asset rules, is that we can't hold an interest in another entity, right? So it means we can't hold any units in another trust. We can't hold shares in another company. So, okay, we're looking at cash at that to start with, right? So it's a cash-based trust to start with. We can't lend money to another entity. Okay, so why have we got cash in there? We'll work into that in a moment there. We can't lease property to a related party of the fund or into a lease arrangement with a related party except for business real property, right? So, okay, so now we've expanded. We can hold cash, right? And we can hold property. Right? We can hold more than business real property. We can hold residential property inside that trust as long as it's not leased to a related party. So our same in-house asset rules apply within the 1322C structure. Right? We can't borrow money in the trust. Right? We can't acquire an asset from a related party of the fund or an asset the fund has, that has been owned by a related party fund within the previous 3 years, unless that asset is business real property. So again, it reflects the Section 66 prohibitions, right? And the prohibitions on acquiring assets from related parties. It restricts it to business real property because we see in the first dot point, we can't invest in other shares, right? So we can't buy listed securities from a related party because we can't hold listed securities inside a 1322C trust. We can't conduct non-arm's length dealings, right? We can't conduct a business, and we can't give a charge over the assets. So it's very restrictive in what we do. And ultimately, as I come back to, it's really a way of unitizing property, right? And whilst there are other opportunities in there, that is primarily what it's there for, is it gives us the capacity. So it's a way of moving property into super without having to do title changes and other things. We can sell units, we can have units owned by the super fund, we can own units personally, and then we can buy those units from ourselves. We can sell those units to ourselves. Yes, we've got transactional and CGT issues to consider there, but the property is still owned by the underlying trust. So there's some key considerations around it. So that's where the beauty of 1322C vehicles come in, is that it gives us opportunities to look at different ways to hold those properties in the fund. But once we then undertake a 1322D event, then we're effectively stuffed in regards to the fact that if we borrow, if we lease an asset to a related party that isn't business real property, if we deal on a non-arm's length basis, right? Anything in those sorts of regards, then we're going to be in breach of the in-house asset rules. It's going to be a related trust not subject to an exception. We're definitely going to be over the 5%, which means we're going to have to put a plan in place to get rid of that asset. Right? There's an overreaching one, the membership increasing above 6. So if a fund has membership above 6, then it tarnishes far more than just this investment. It tarnishes the entirety of the fund. But whereas 1322D events are specific to each trust, if you've got multiple investments, the membership one would tarnish all of those investments. So it's a fairly important set of rules to understand. I know I've got questions. I've got to go back to work after the webinar and ask some questions that I've had related specifically to 1322C that have come across my desk late yesterday afternoon. So it's still a very relevant situation that we find ourselves in with these funds. So again, let's look at Pat, right? Pat wants to buy a house from a third party using money from a self-managed super fund, and personally by subscribing for units in a unit trust. So we're taking the exact same situation that Pat was in before with the whole tenants in common, but instead of buying the property with himself, they're buying the property through a unit trust. So as long as they're not buying that property from himself, then that's fine. So as long as it's not being purchased from a related party, that's fine. Can the fund buy Pat's units? Now, this is where the 1322C becomes more comprehensive ultimately than say the Section 66 requirements, because here we're buying units, we're not buying the property. So all we have to do is make sure that those units and that unit trust is still meeting the conditions of 1322C. And in this instance, we can buy Pat's units. So that is far more powerful than trying to buy residential property directly. What if Pat rented the house? Well, then Pat's done the wrong thing. It would become an in-house asset. Not only would it become an in-house asset, you would have to unwind the trust because you breached 1322D. But what if the asset was business real property rented by Pat's business? Then that's fine. There's no problems there. What if it was geared? Then that's an issue. It would be an in-house asset and problematic. What if the unit trust purchased some shares or started a business? Okay, going through all the issues, in-house assets. So you can see the in-house asset rules themselves are quite restrictive. Related party, related company, related trust, asset subject to a lease, loan, right? They're fairly restrictive. But then the exceptions provide some huge potential benefits to the fund, and that's what we need to keep our eye on to ensure that if we're dealing in this space, we are doing the right way. The other thing, and I've mentioned these briefly before, is I mentioned 1999. So basically, if you had an investment before 1999, so 12th of August is the day that these rules came in. But if you had a pre-1999 investment, as they're commonly referred to, and under the old rules, those investments were not in-house assets, then under the new rules, those assets are exclusions to the in-house asset rules. So it's quite powerful in the sense that if you invested in, and most of the time we're talking about pre-99 unit trusts as such, if you invested in a trust that did have a property that was leased to a related party, well, as long as that property is still leased to the same related party or still released to a related party, and the terms and conditions, I mean, obviously commercially they've changed, but the lease has been unbroken, then that asset is still acceptable under the old guidelines. As I said before, there was some transitional arrangements in place that provided for the ability to invest more units and to potentially pay off borrowings. All of that had to be done before 2009. So any pre-99 investment that has a new investment made now, that new investment will be an in-house asset, right? So if we've got unpaid present entitlements, unpaid trust distributions, and we want to look to reinvest them, then what we have to make sure we do is we look and go, well, can we invest in that trust? Because if we do, will it meet the definition of an in-house asset, or will it meet another exception? Because it can't meet the pre-99 exception anymore. And this is where 1322C comes in. So now, if you're making a reinvestment of a pre-99 trust, and the trust now satisfies all the conditions of 1322C, so there's no borrowings, it's business for property, lease to a related party or whatever, all those sorts of elements, then any new reinvestment could potentially come in as a 1322C. But you're tarnishing that entire trust then as a 1322C trust, whereas if you're not doing reinvestments, then that trust is still eligible to borrow, that trust can still conduct businesses and other things, of course, subject to the biggest caveat of all, and that is the sole purpose test, like what is the purpose of that transaction. So there's some key benefits to those pre-99 investments. So the in-house asset rules really that are critical for us to understand from a practical sense, right, is that our total in-house assets cannot exceed 5%, right? So as I said, there's 2 times that we're testing in-house asset rules, right? There is the acquisition point in time. So if we've already got existing in-house assets and they're below 5%, then we're looking to invest in more in-house assets, then we can only go up to 5. It's not 5 each asset, it's up to 5 in total. So any new investment that is going to put you over 5 is prohibited. You can't actually go and undertake that investment. Then we do our test on the 30th of June, right? So we take our in-house assets. Is the value of our in-house assets greater than 5%? If it is, we have to act, right? Now, this is where the legislation becomes interesting, because going over 5% is not actually the breach, right? So going over 5% is not the breach of the legislation. What the legislation says is if your in-house assets, when you do the formula to determine your valuation, and that formula is based on gross value of the assets, not net value. So if you've got LRBAs, you don't take the borrowings into consideration. You take the value of the asset and you measure against the in-house assets. If you're above 5%, the legislation requires the trustees to put in place a written plan by the end of the next financial year that identifies which in-house asset will be disposed of to get the assets back below that 5% limit, right? So it's a very specific set of plans that have to be written, and that is what assets are you disposing of to get yourself below that 5% rule. So in history, I've heard all of the opportunities, or what if I contribute more, therefore that'll put my asset below the 5%. Once you've gone over the 5%, that's too late. The only time that was a successful strategy was ultimately during COVID, right? And effectively the ATO put in place powers, or the Treasury put in place powers for the ATO to say, don't invoke the in-house asset rules if the market value of the assets of the fund have dropped, therefore putting the in-house asset rules over, or the in-house assets over 5%. Let's not make people sell whilst we're in this COVID position here. So if you do go over 5%, then you've got to put in plan in place to sell. However, what you should be doing is reviewing your in-house assets towards the end of a financial year from a valuation point of view. And if there's any potential opportunity that it's going to be over that 5%, then look at, is there an opportunity to utilize bring forward contributions? Is there another way that we can put more money into the fund to ensure that come 30 June, we're not over that in-house asset limit? So it's critical that we get that understanding right. So look, what I want to finish with before I talk about the potential penalties and issues that can go with it, and summarize those key questions that I ask in in-house asset, I just want to sort of touch on an old favorite case, which is the Aussie golfer case, which is an interesting one because firstly, the tax office determined that it was a breach of both the in-house asset rules and the sole purpose test. But what you had was the super fund, right, the SMSF down the bottom there, investing in this Domicom product, right, the fractional property investing, and between the family members, 100% of the investments in this Burwood sub-fund were related investments. But they were taking the approach that the Burwood sub-fund was just part of a broader Domicom fund, and therefore overall the investment by the fund was not an investment in a related party. Right, so the ATO looked at that in the first instance, and so the issue was it was student accommodation and it was leased to the daughter of the SMSF trustee. What the ATO deemed in the first instance was the ATO themselves said, well, we've got the power under the SIS Act to determine an asset to be an in-house asset, and on face value, this looks like an in-house asset, so we're going to call it an in-house asset. What the courts actually said was, well, actually the sub-fund itself is its own trust, right? So we're discounting everything else that's held within the Domicom product, and we're saying that this trust is the exclusive investment of the fund, and therefore 100% of the investors in that are related. So it is a related trust. So it's just an in-house asset under the normal definition of an investment in a related trust. And so in essence, the fund breached the in-house asset rules, right? Because, and the investment from a super fund point of view was only about 8-9% of the total value. So it wasn't significant how much they were over, but it was enough that they were over the 5%. And so they effectively had to sell down the asset. But it sort of gave a broad picture of trying to enter into certain schemes that work around the in-house asset rules. And that's effectively what they said the Domicom product in that sense was, it's not a way for you to be able to invest in residential property and lease to related parties, because we're going to look and identify those sub-funds individually, and then it's all the investors in that will determine whether or not the investment is a related trust investment. So it was pretty critical in the whole scheme of things as to how we can structure some of these investments moving forward. There was, as I said, the tax office also determined it was a breach of the sole purpose test. The courts actually, they appealed, and the courts rejected that, and they said, well, the fund had indicated in their investment strategy that they were looking at these types of investments. So the fact that the daughter moved in there, and it was to no financial detriment to the fund, felt that it wasn't a breach of the sole purpose test. So as we finish up, from an investment restriction point of view, the key thing about in-house assets is they do have links to other investment restrictions. I've just mentioned investment restrictions, as I've just mentioned there with Aussie Golfer, sole purpose test being one. As I highlighted earlier, that key issue around loans and financial assistance. It's okay under 71 to lend to companies and trusts. It's not okay under 65 to lend to members and relatives. So you've got those nuances to contemplate there. The whole acquisition of asset from related party, I said that's going to be the primary focus of our webinar next month. So there's a number of key issues. And then when we look at from a penalty point of view, it is a civil penalty to breach the in-house asset rules, and that is to not put in plan and execute put in place a plan and execute that plan. Something pretty critical to be mindful of. But also then you've got admin penalties, which is more likely where the SMSFs are going to be hit if they're breaching the in-house asset rules. So I said I wanted to finish off with basically the questions that I pose to people in these situations. And so the first question that should always be asked, so you don't look at values, you don't look at anything else first. The first thing you always look at is, who are we dealing with, right? So who is the self-managed super fund transacting with, right? If it's not a related party, then you don't have to ask any more questions, right? I mean, you still got your arm's length considerations and things there, but you don't have to ask any more questions. If it's a related party, then you have to know, okay, well, if it's a related party, is there an exception to the rule? So if we're looking at acquiring things, as we'll talk about next month, what are the exceptions to the acquisition rules? If it's an investment in a related party, is there a 71(1) exception to the in-house asset rules? Is it a 1322C vehicle? What are we looking there? If there's no exception, right, then we're restricted. Then the next question is, what's the value, right? And that's where our 5% comes in. If there is an exception to the rules, then the valuation is not relevant because we can invest up to 100% in those investments. So always start with who we're dealing with. Once we know who we're dealing with, then we look at what are we investing in. And then once we know what we're investing in, then the valuation becomes important. Don't start with it's less than 5%, so it's okay, because it might not be okay for many other purposes. And then know that if we get things wrong, then there's things that need to be done and potentially penalties to be imposed. So that brings us to an end for today. Next month, acquiring assets from a related party, and then in December we'll talk about trust investments in a self-managed superannuation fund, and that's where we'll take a deep dive into the pre-99, into the 1322C, into unrelated trusts, into LRBA trusts, and how they all work as an investment vehicle from an SMSF point of view. So thank you for joining me today. I look forward to you all being online again in November. Until then, have good month, good day, good week, good month, and we'll see you all soon. Thanks a lot.